Good afternoon, everybody. I'm Matt Gibson, Head of Pensions Covenant Advisory at BDO. And thanks very much for joining us on this webinar on the Pension Schemes Act. The new Act is going to impact both regular transactions and restructurings. And before I hand over to Raquel, I'd just like to briefly set the scene with what we see in these markets at the moment. And in short, what's been happening is not what we expected back in March last year. Many people, including us, expected there would be a substantial increase in the number of insolvencies and transactions would dry up. But just looking at the first slide, we can see that the number of insolvencies started to fall in March 2020 relative to 2019, and then fell away quickly and stayed well below the previous year until December, when there was a bit of an uptick. I looked at the numbers for January this morning, and there was only 750 company insolvencies in January compared to 1,500 in January last year. I've also set out a breakdown on the slide by the number of insolvencies by type, which paints the same picture of much lower insolvency volumes in 2020. In fact, the total number of company insolvencies in 2020 as a whole decreased to the lowest level since 1989 and experienced an overall year-on-year fall of nearly 30%. So just turning to the next slide, which looks at the picture for M&A. And although M&A transaction volumes fell off notably in the second quarter of last year, you can see that they rebounded very strongly in Q3 and Q4, both in terms of number and total value of deals. And this trend has continued into 2021, and our M&A and transaction services teams are currently extremely busy. So briefly, what's happening here? Well, as you may have guessed, insolvency numbers are going down largely because of government support, and the government prohibited corporate winding up, the forfeiture of leases, and also promoted non-aggression by banks. And all this was backed up by the furlough scheme, C-bills and CCFF facilities. And we've now seen these measures extended on a number of occasions, most recently until April 2021. And of course, we may get further extensions in the budget next week. But sitting behind this, though, many corporate balance sheets are now much more highly leveraged, and many markets, I think, will find have changed massively as a consequence of the pandemic. And also, as activity levels increase coming out of the pandemic, experience tells us that working capital requirements are also likely to build, and this can frequently cause liquidity pressure. So we could be seeing more stress out in the corporate market as some of the restrictions get lifted. So whilst the government will wish to avoid a cliff edge effect when support is ultimately withdrawn, at some stage, maybe later this year, we could be in for a significant increase in the number of insolvencies. So just from an M&A perspective, 2020 was a year like no other, and yet, following the Q2 lockdown shock, the M&A market showed a remarkable recovery. Deal volumes picked up pretty substantially in Q3, then soared impressively in Q4. And just asking colleagues at BDO, there's no clear answer to why this upturn took place in M&A, but it seems to have been driven in part by significant levels of financial dry powder out there, and the weight of money, which still remains huge. And some estimates put the total amount of, call it dry powder out there, to be around 1.5 trillion globally. Debt markets have also remained open and have supported sponsor-led transactions. And I just saw this week that Avis had raised 600 million senior secured notes at the start of the pandemic at 10% coupon, but have just managed to refinance that on an unsecured basis at half the cost. And the other thing that was out there was also potential talk of changes to CGT, driving entrepreneurs to seek early exits, although we're not convinced that that's materially impacted deal volumes yet. So overall, the immediate outlook for transactions therefore continues to look favourable, but we're anticipating challenges ahead as those much talked about recessionary pressures begin to bite. And we're also now seeing some tightening of the position of banks, and the recent level of activity on the capital markets may now slow later in the year. So in summary, and this is caveated by what the impact of the wall of personal and corporate spending power out there will be, we expect to see near-term continuing strong numbers of transactions, moving over time to more restructuring and insolvency activity. but just how this will dovetail with the new Act remains to be seen. Anyway, now I'm delighted to welcome Raquel Agnello QC, who some of you no doubt will have met and worked with. And Raquel is uniquely well qualified to talk to us today, as she's a leading QC, both in the pensions and insolvency fields, and also an expert on moral hazard provisions. Raquel has led many high-profile cases for the pension regulator and others, including Nortel and Lehman in the Supreme Court. And she also advises on pension restructuring situations, including most recently on Cobham and a couple of years ago on Johnston Press. Raquel's also a long-standing Deputy Insolvency and Companies Act judge and has won many accolades as a barrister. So I'm just going to hand over to Raquel shortly, and as we go through, please feel free to ask questions in the Q&A box rather than the chat box, and then I'll pick those up as we go through and pose the questions to Raquel when she's finished. So without much further ado, over to you, Raquel.
Thank you very much, Matthew, and thank you for that great introduction. Welcome, everyone. Right, it's now the Pension Schemes Act, but before you start all getting worried and scared about it, the new regulatory powers and criminal sanctions, which I'm going to talk about, are not yet enforced. We believe in autumn 2021. If there is one takeaway from today's talk, please, 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 and I'm not employed by the government when I say this, but TPR is currently going through consultation, will issue guidance. This is really important to engage and make your views known, because there's lots of questions in respect of these new regulatory powers. Some of them are going to be set out in guidance, there's issues raised in consultation. So this is your chance to change it. What is meant by reasonable excuses may not come up, but if you know how the structure works, if you know what the TPI guidance is going to look like, that helps you know what it is. Any person, we're all scared about any person. What does that mean? Does it include, for example, me as a silk acting on something? Does it include Matthew giving advice? We all want the answers to these. And these are sorts of issues which you need to look on the consultations. You need to provide your opinion on it, because these acts, the provisions I'm dealing with, will come in force. And the more we engage, the better. Now, one thing before all of you think, well, if it's not coming in until April 2021, I have time. Just remember that in many cases, when you're dealing with the reasonable test, you will sometimes be able to look at matters which have occurred prior to the date in force of the relevant provisions. So even though there's been Parliament saying that it's not to be applied retrospectively, be aware of what that means. I only have to say to those of you online, box clever, to know that even when you have a start date, you can still go back. Slightly different, that was an FSD and not the CNs, but just be wary of it is the point I want to make. It is something which is supposed to be scaring all of us. I think scares make good headlines. And even just last week, there was a fantastic new scary point coming up in an insolvency website saying, oh, look at all these new powers. And the article was terrible because it didn't say, A, they're not enforced yet, and B, they didn't explain that there's still more guidance to come. So, you know, people like to be scared. It's a bit like horror films, which incidentally I don't like. So there we go. Right. Anyway, so what are these changes? Now, the major changes are, and again, for your takeaway, remember, we are talking about new civil and criminal sanctions and liabilities. Valuation, if there's one word you take away, it's valuation is king here, it's key. And the third point is record keeping. I'm always told by clients when I say, have you kept a record of that? They say to me, live in the real world, Raquel. Well, I'm now saying to you, this is the real world. Record keeping will be key. Let's look at what our major changes are here. First of all, expansion of CNs. 2 new tests for us to play around with: employer insolvency test, employer resources test. I come back. Civil penalties applying to avoidance of employer debt, conduct risking accrued scheme benefits, and then you have criminal offences, which is what always scares everyone. And again, you need to remember that civil penalties and the criminal offences are quite wide. Again, connected and associated is out the window, so to speak, on those two. Right. other new major changes, and these are the ones I think you're going to see hit as soon as these provisions come into force. The expansion of giving notice to TPR, the statement of intent, the new 69A. Now, I can't talk ad nauseum about this because we're still waiting for those regulations. They'll be consulted upon. But I think that the takeaway on that is they will be wider. They are deliberately designed to make it possible for the regulator to get more information earlier. And so that's what you need to remember. That's what it is. It's going to create a lot more work for advisors. You're going to have to identify when exactly you need to do this. The other point is, I think that these documents were going to have to be very carefully drafted. I'm not saying you need to use me for it, but you need to be careful with them. The expansion of Section 72, another huge change. That includes an interview with TPR. And there's a civil penalty for failure to comply with a Section 72. These are the changes which I think you're going to see, what I say, almost instantly having to grapple with, yes? The others, let's explore them a little bit. Right, so we are now looking at what are the consequences, and I've sort of just dealt with that. I think that CNs are really going to be a question of valuation, the new CNs. 72 is extraordinarily wide power given to TPR. And the reason I say that, I'll come back to it in a moment, is that in my other world, which is insolvency, when a liquidator or an administrator wants to go fishing for information, and I'm using the word fishing, it brings a section 236 application and says, I want to know about X, Y, and Z. And that needs to be sanctioned by the court. The court weighs everything up. 72 has none of that. 72 is the regulator, who of course has to act reasonably and within its powers and so on and so forth, but it doesn't have to go through any court screening. So it can be terribly wide, yes? This is one of the reasons why, and the other point to remember about defences on the consequence of proposed changes, defences. Some of the defences you can raise are, oh, well, I thought about it at the time and these are the steps I took to mitigate. If you're going to run those defences, you need to ensure, in a way, your records are divided into privilege and those are prepared for defence purposes. Because if you want to run a defence, you may be grappling into privilege areas. And that's something which any lawyer who talks about privilege always starts with a big sigh, then goes to one of the textbooks. It's a really difficult area. Now, we're going to touch upon, if we've got time, our civil penalties enforceable overseas. And the question everybody always asks me, and you all have in mind, are the expanded powers really simply to give TPR more leverage, or are they going to be used? It's very difficult to answer that because they look, and some of you might think, well, you know, do we need all of these? They had all these powers already. I think in a way, I would say this, these new powers are going to make people think more carefully about what they're going to do. That doesn't mean to say they won't take the risks. And I think the real thing that we need to do is work out what's the position of the professional advisor in this. Right. Good news, bad news. Well, I'm trying to find some good news because most people hate change. I think the good news is, for those of you involved, there's a lot of valuation work which is going to come in. So you need to assess it. It may make it more expensive, but you see valuation evidence is key in respect of the new tests which are coming in. The only escape is for insolvency practitioners, but even that is narrow. And I say this because IPs, what work IPs do these days is very different from the work that traditionally we think of IPs. Traditional IP work is they get appointed administrators, liquidators, so on and so forth. But most IPs these days have a much wider practice. If it doesn't come within the definition of what is a licensed insolvency practitioner does under the Insolvency Act, you will not be under the exemption. Beware, be careful. A lot of work done by IPs on transactional work isn't necessarily IP work as defined. So you need to be careful. Criminal sanctions, very wide. I've already raised this, and what's meant by reasonable excuse. Now, I'm going to do a little bit of history. I'm afraid you can't get rid of history because this, I think, really helps put this into context. Right, the original Section 38 test, when it was brought in, was prevent the recovery of whole or part of the debt, or seeking it to become due, or compromise or settle. So it was an intention-based test. Very difficult for TPR to establish the intention. And so it's not surprising that there are not that many cases around. Cases which ended up going to court was Bowness and Desmond, which most of you will know about. And there was an early guarantee stripping case which settled outside the DP. But the guarantee stripping case I'm going to talk about just briefly demonstrates the sort of things which are covered by this. That was a very amusing case where there was actually in the corporate structure a guarantee in respect of the Section 75 debts. And what the company group did is they tried to persuade the trustees that they were absolutely bust and they didn't have any money. And they kept, and the regulator had acquired the emails, which were great. They said, don't tell them about the guarantee. So there was a company in the group which had given a guarantee which had a lot of assets, but nobody was telling the trustees about the existence of this guarantee. So it's don't tell them guarantee. There was a compromise, there was a CN. Naughty conduct cases are the sorts of ones which were caught by the old Section 38, but even then you needed the evidence. So there will be other cases where settlements were reached, cases where there was a threat. But the real difficulty for TPR in these cases is establishing intention. So unsurprisingly, by 2008, the legislation had changed. It had added the material detriment test. So you went from something which was subjective, prevent the recovery of with an intention, to material detriment test. And this was the act failure detrimentally affected in a material way, the likelihood of accrued scheme benefits being received. Comparative factors is what you're looking at, the position before and after the act, whether any person could discharge the scheme obligations. A few cases in this, Carrington Wire was one to do with the Russians, and there was a settlement and another party where they had sold the shares without notifying the trustees. Clearly naughty conduct, if I could put it in those terms. And Carrington Wire fell under both prevent the recovery of and material detriment. So it's not a really helpful case, not because it wasn't interesting, but because it covers both. Others were settled, GPG, BHS, I don't count about Dominic Chappelle, but I mean, they were settled. So what we don't have in respect of the material detriment test is any cases where we can see the defences being run. And this is quite important because the defences have always been, when these provisions were brought in, the key to why there is a wide provision. Oh, they say there's a wide provision because there's this test. Were you aware of this was going to be the effect and the mitigation? Now, one of the reasons that perhaps you don't see the defence being run is going back to what I said. When somebody takes advice, it has to decide whether that advice is to be shared or not. And on that basis, if you are running a defence, it's like opening your files. So you need to be quite careful with this. But for current purposes, it's frustrating that we have no defence being run, so we don't know how it works. But anyway, so we had the material detriment test. Now, the new tests are, if you look at this as a, you have very subjective, objective with a subjective defence, and now we have something which looks completely objective. It's a little bit like a tick box exercise. There's still reasonableness though, don't get me wrong. But if you look at the employer insolvency test, it's a comparison. It's looking for a material reduction, and don't ask me what material means, in the amount of debt likely to be recovered by the scheme. So TPR is going to estimate the value of assets immediately after the act and failure, and also the amount of Section 75. There's going to have to be a determination of the Section 75 calculation and other calculations. You have the same mitigation type defences as before, those which we've never had tested. So that's not very helpful. But you can see how this becomes really valuation based. The second one is the resources test. Now, this is where you have a reduction in the value of the resources of the employer, and the reduction was a material reduction relative to the estimated Section 75 debt. So that's an important comparison that you see there. There are going to be regulations which are going to set this out. For those of you on this webinar who have ever had the joy of dealing with the insufficiently resourced regulations, I think the first thing you all need to answer to the regulator in consultation is do not do the IR regs again. They are a real nightmare. They're difficult to deal with, they're difficult to follow, they are uneasy. Please, please, please give us something which is easier. And one of the problems is, in all the cases I've done where insufficient resource tests have been carried out, whether in the past I acted for the regulator or whether I've acted in respect of looking at it for trustees or for potential targets, there's more than one way to look at them, and they can always be challenged, is my take on it. So what we really would like are easy to use regulations, but valuation will be king. The defences for this will be as before. Right, history lesson over. Let's see where we are. Well, history and up to date now. Widening of the CNs. So it was probably, as you've probably guessed while I've been discussing the history, that the old tests were too narrow. I absolutely get that the prevent the recovery of, as I abbreviate it to the original Section 78, was far too difficult. I mean, it's an intention test, always difficult. Material detriment was wider. So what will the new tests catch, which was not caught before? And that's the real question we have to ask. Now, the new tests are very similar to my happy hunting ground of transactions of non-value under the Insolvency Act, which is all based on what the consideration was in money and money terms. Simplistic, but that's what you're looking at. You will find that the real key that you need to do in this area is to realize how you challenge the valuation evidence presented by TPR, because that will be key. And when you're advising clients about whether to do a particular transaction or not, it's your valuation evidence which is going to be key for defences, and not necessarily the defences, a defence of saying, this doesn't fall under here, look at my valuations. It's not necessarily the mitigation defences. Right, let's just try to do a really mini case study. I mean, these are never as easy as this one, but let's try to do a little case study to see how this works out for us. So you have company A, it's gone through a restructuring, it has a great business. This was pre-COVID, by the way, I should mention this when I did this example, so don't ask me about COVID coming in. It has no secured debt, we like these companies. Unsurprisingly, with no secured debt and cash and resources rich, it's obviously come to the eye of some private equity. Large pension scheme, you had SSF agreed, it was meeting its contributions, happy as they come. Sums were paid though via its profitable US subsidiaries rather than the employer itself. Does it matter? No, because the US subsidiaries belong to the employer, all the money comes out, the pension contributions being paid. Proposed share acquisition by private equity via a scheme of arrangement. So this is under the Companies Act, funded by the proposed secured debt on the employer company, plus moving up the US subsidiaries. So that's our little mini structure there. So let's see. Now, the first thing to remember is a proposed scheme of arrangement doesn't concern the pension scheme and the trustees. All it is offering the shareholders a different deal, a return on their shares, a payment for their shares. And as part of the transaction, but not something to be sanctioned by the court, is that you're going to actually put the debt as secured debt on the company, and that's what's funding the share acquisition. But that's actually not what is going to be sanctioned by the scheme. The scheme only sanctions, so to speak, the share deal, not how you're funding. So you've got straight away an issue about how that could be challenged. But anyway, let's just have a quick look at the new employer resources test as far as we can see. Value of the resources are obviously reduced by the creation of secured debt and the removal of the US subsidiaries. Probably meets the employer insolvency test too, value of the assets reduced materially. So you're left with defences, recognising what the Act would do and proposing mitigation. How much? How are you going to mitigate that? Something I've never quite known the answer to. If you find something which you say is going to fall under a CN scenario, even under material detriment, and you've proposed mitigation, does your mitigation have to equal what you've taken out? How has it worked out? That's one of the frustrating issues in my book as to the fact that the defence is in place, but we don't know how it operates. Now, what about under the old tests? Material detriment, I think my little case study would fall under here as well. the Act places the pension scheme in a worse position than before. So it probably would. Mitigation defences would be open. What about the old traditional prevent the recovery? Hard to see on my summary of facts. It's all to do with a share acquisition. It would have to be one where the dominant purpose was to avoid the pension scheme. And it probably wasn't. The dominant purpose, or the main purpose, was, to fund the share acquisition by putting on the secure debt. So material detriment would probably be okay. The old prevent the recovery, no. Now, stay with me. There's a reason that we're now going to these things. So that's my little mini test for you to see. I think the key to realize is that there's probably cases which would still fall under material detriment, but it will be probably more cases potentially which will fall under the new ones. Now, civil sanctions. You've got a civil penalty for failure to pay the sums due under the CN. I'm not going to talk much about that because here's the deal. If you've got a CN against you, you have to pay. So if there is a creation of a civil penalty, as professional advisors, we're not in the picture for that, yes? Civil penalty for conduct risking accrued scheme benefits. Section 58D. Hang on a minute. This is the material detriment test. So you have a civil penalty if what you've got is what I call the old material detriment test. That's section 58D. And if you look on screen, you'll see that that's exactly the wording that's being used. Go. Section 58C is the other civil sanction, party to an act, the main purpose of which was to prevent the recovery of avoidance of employer debt. So your civil sanctions, leave out the one about failure to pay the sums, are twofold. Old material detriment test, avoidance of employer debt, yes? Hang on a minute. Didn't I just, in my little mini history, do you see how history is important, explain to you that there were very few prevent the recovery cases because it was so difficult to prove, and that we've widened so that because material detriment wasn't really meeting it. So the civil sanctions relate to the historic provisions, but it is widened a little bit. Who's liable under the civil sanctions? Now, failure to comply with the CN targets, yes, boring, leave that to one side. Under the material detriment, a party to the act or to the deliberate failure to act. So you just have to be a party to the act. Remember, those who knowingly assist are parties to the act. And here you have the additional bit on civil sanctions. The person must have known or ought to have known that that act or failure would have that effect. And it was not reasonable for the person to act as they did. Avoidance of an employer debt as well. But what you do have coming out of this is the connected and associated test. It no longer, it doesn't apply to the civil sanctions. So that's where it's wider. So what you have is more people that can, more individuals or parties that can be caught under the civil sanctions. But the civil sanctions relate to the old prevent the recovery and the material detriment test. And the TPR has to establish a knowledge element. So it gets a little bit subjective objective in there. Known or ought to have known that act would have that effect, yes? So what if you have a case where you advise and you say to the client, look, this may or may not work. I think you've got a decent argument, so on and so forth. And they do the transaction, yes? Are you, as someone who's advised, knowingly assisting? You didn't tell them to do it. You said it's a possibility. Do you fall under it? Is that a problem? What if you are the solicitors carrying out the paperwork? Are you going to fall into it? Are you knowingly assisting? What if your defense is, well, we took advice and we had a reasonable argument that this didn't fall within here? I think that last one is a defense, and it's a good defense, but here's the deal. Are you really going to take the risk and have to reach that stage? This is why, in my opinion, it's so important that we get some guidance about this. Now, absolutely get on the really naughty cases, go back to my amusing guarantee stripping. That kind of a case is going to be caught any way you look at it, yes? But that's not what we have in most of the cases. Now, the defense. Here comes the reasonable defense, the reasonable excuse. TPR has to establish that it was not reasonable to act the way that the persons did. This may be a good let out for a lot of professionals. Is this wider than your old mitigation defense? I think it is. What about professionals covering advice? I've just given you an example. I think if you've got an argument which says, look, as far as we're concerned, there's a good argument, this doesn't fall in there, I don't think you can say it was unreasonable for you to act the way you did. Again, be careful with your exemptions for IPs, only if they're acting as IPs, remember that. Now, let's just apply the civil sanctions to the case study, because that's what we really want to know. So what about 58C? That's the prevent the recovery of. Hard to tell that you would fall under that. I suspect not. As I said, the purpose was really a share sale. It was acquiring this really nice corporate entity with all its wonderful US subsidiaries. It wasn't, the intention wasn't to dump the pension scheme or prevent the recovery. It was an acquisition of shares. And it's quite normal on acquisitions of shares. You're going to do the leverage, as I said, where the share price ends up being secured debt. That's what happens in these transactions. The 58D private equity probably caught, as it knew the act would have the effect, and it was not reasonable to act as it did unless it offered adequate mitigation. Just pause there. So as private equity, you're looking at it and you're saying, well, yes, I know I put secured debt there, but that was the deal. And the answer will be to say, well, that was materially detrimental. So it leaves the scheme worse off. So this is where, in my opinion, on my little example, you're going to have the risk. Yep. What about the private equity's advisors? Knowingly assisted, my problem here. You provide advice and analysis. Does that mean to say that you've knowingly assisted? I mean, I don't have the answer to that, which is a really bad thing to say because people come to lawyers for answers. But knowingly assist is very badly defined and dealt with in case law to date. And it's a phrase you find quite a bit. So the answer to that is more work for the lawyers. No, is that this is where you need to be really quite careful. And hopefully we can get some decent guidance which tells us who's caught and who's not caught. I don't think any of us have a problem with the really naughty ones being caught. It's the grey area, which is very frustrating. Right, so if you're still with me and you're not completely depressed, and I'm still trying to make you feel happy about this, let's go on to criminal offences. So the failure to comply with the CN unlimited fine, again, let's just leave that to one side. The avoidance of employer debt is unlimited fine, 7 years in prison. But just remember that this is the old prevent the recovery of. Remember what I said about intention, and we'll come back to that. And then the risking accrued scheme benefits is your material detriment. So your civil sanctions and your criminal offences are pretty much the same. However, the act must have the effect sought and refers to the act or the course of conduct. So that's an additional matter for criminal. Now, for those of you who are here, who still remember doing crime, and I still remember just about doing some crime in my early practice, there is a higher burden of proof. It's beyond reasonable doubt. This straight away makes it difficult for the regulator because the burden of proof is so high. Up till now, you're looking at balance of probabilities. Now you have beyond reasonable doubt. And that is point one about the criminal offences. Point two is that regulator has to establish at that standard of beyond reasonable doubt that the act or the course of conduct had the requisite effect, i.e. it was intended to have that effect. There was the knowledge that that is what would happen. So that makes it a second difficulty for the regulator on this. And the no reasonable excuse. So the knowledge, the burden, and the intention which comes into this. And remember as well, you're dealing with prevent the recovery of the old section 38, which wasn't really fit for purpose because it was so difficult to establish under balance of probabilities and material detriment. So let's just play around with our criminal offences and case study. In my opinion, you're not going to get anywhere close to avoidance of employer debt beyond reasonable doubt on the prevent the recovery of in my little scenario. You might get a little bit further material detriment, but private equity could run reasonable, lack of knowledge seems unlikely, they knew about it, but the effect of your acts. So this is where you see that it could be potentially wider. Do I think these criminal offences are going to be used by the regulator? Well, I have no crystal ball, and there's no way of telling. Are they only going to be a deterrent? I don't know. But the fact that the regulator has got civil sanctions and criminal sanctions is important for everyone to realise. There is, again, in criminal, no connected and associated. You need to be careful, you need to be aware of that. Knowingly assist a party to the act, yes? But it deals with the older provisions, if I can put it in those terms. Right, so let's just to press you a little bit further. Stay with me on this. There is, as I've said, also some good news about it, which I've gone through, not much. Right, criminal offences and civil, can they be enforced overseas? Now, I have frequently, as I'm sure a lot of you on this webinar have dealt with foreign entities who have received a Section 72, and they come to you and they say, do I have to comply? And if you look at the case in the old laws of Soccer and Perry, the answer was no, because the old Section 72 was formulated that it was a criminal offence. You could be prosecuted if you didn't comply under Section 72, subject to the defences which exist there under. But Soccer and Perry was a case, Supreme Court, which said that you can't enforce that overseas because it's a breach of criminal law, of international law, if you are criminalising an act which occurred in one jurisdiction and you try to rely upon it in another one. So the answer to that is that the criminal offences, Section 72, for example, can't, in my opinion, be enforced overseas because of the decision of Soccer and Perry. However, civil penalties and sanctions don't necessarily create the same breach of international law. Civil penalties and sanctions are very weird things, and I say that because in the good old bad old days, you had criminal offences and then you had civil matters. Civil sanctions and penalties are quite new. They're new animals which have come along. And so I don't have a case which actually analyses whether they would also be a breach of international law. Was this deliberate? Did TPR really want to give itself these civil sanctions to avoid Soccer and Perry? I'm not sure this was thought through. I think it was really, and this is me being fair, I think it was really to try to get a quicker way of dealing with disobedience and taking it through criminal courts. But it's for TPR to select when it brings criminal or civil. So when you are advising the corporate group overseas and they say, I've received a Section 72, the old simple answer was Soccer and Perry, let's have a cup of tea or a drink, goes away. You have to start looking and saying, hang on a minute, how are civil penalties and sanctions going to actually be defined here? So that's something that I don't have the answer to, I'm sorry, but you need to be quite careful with. Right. Here's the thing everybody really wants to know. It's the provision of information and notification. First thing is that you have your interview requirements. And what I don't know is whether you're going to be provided with the questions beforehand, and then you go there and answer them. Do you need to have your lawyer around? Yes, 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 and yes. It's very wide as to when they can call you. One or more matters specified in the notice that are relevant to the exercise of TPR's functions. And as I said right at the start, unlike an insolvency where, you know, we're always pushing the boundaries, but the judge says whether we can have it or not under 236, you have no court control here. You do have, though, unlike if you've got liquidators or administrators or office holders, you do have a public body subject to public law who has to act reasonably. But apparently when the consultation took place about the widening of this, nobody said, why can't you go to court and ask for it? And so you're left with the public body having this very wide power, and your only way to really control it is judicial review. If TPR, you assert, is not acting reasonably. Now, we really need to see the statutory instrument, which is supposed to come out, to see what information the regulator has to provide. I mean, when you read it, it's really wide. But when you think that one of the things, certainly under 236, which the court weighs up, is the prejudice to the person who has to provide this. All of you have had to deal with a 72 will know that they are eye-wateringly expensive to deal with for your clients. And I'm afraid none of this assists. It's like a public duty is what I always tell clients when they say, do I have to answer this? I'm going, yeah, because you're not going to get into a fight about whether this is relevant or not. The regulator needs information to assess it. And if you say, well, you've got it already, you know, it's not a defense. So you've got to be careful about this. There is the new civil penalty for failing without reasonable excuse to attend or provide information. And that may very well have an overseas effect if you can't squeeze it into an analysis of Soccer and Perry. So this is something where we all need to watch the SI, and we have to see when this occurs, because it can be extremely onerous. This is the other area where, frustratingly, we still don't have enough information, which is the statement of the accompanying statement, the statement of intent, description of events, any adverse effects. Now, just on the little that we know about section 69A, I would say the following. This requires quite a lot of input from professionals. I think it requires quite a bit of looking at it and deciding how exactly you're going to write it, not because you're trying to get away with anything, but this document can be extremely important in respect of the way the regulator goes. So this is going to take some time to do. And also, because you have to do it so early, you may find, and I simply raised this, that the position on day 1 is different from the position on day 20. If, go along to my little case study, if somebody said, well, I want to buy this, is that day 1? And then you need to make a declaration then. But as you go through it, the deal may change. How much secured debt, the price of the shareholding may change. And so do you have the possibility to put a new one in with better, not better facts, with more information, better detail? All of these things I don't know, we have to wait. But what I would say is that the statement can act as a defense or create a potential liability. And that's why this is a document which, in my opinion, requires a lot of thought, not because you're trying to paint things in a better picture, but we always do, of course, want to do that, but that you really need to provide enough detail to justify what is going on. You have financial penalties here. They're over max of 1 million. Well, let's not get scared about that. The real key about this, again, is to make sure that when you have consultation about the regulations, that it becomes easy to do, on my example, to put in an extra additional details to give. Just pausing here, why are we making life so hard for everyone? I think it's fair to say that a lot of deals which have gone down in the past go down at a stage where perhaps the regulator now wants to be informed earlier. Are they going to act? I don't know. But they want the information earlier on. The difficulty with wanting information earlier on is that you're going to be swamped with early information, which may be altered. And you may find that people decide, I don't want to do anything. Those who are going to get out of the market. I don't think so. I think what you're going to get is people who want to play it more safe, but the burden is there. And the other point to remember for those of you acting frequently or who are trustees is that you will have cases frequently, and I'm sure a lot of you have dealt with them, where trustees are frustrated by the reaction of the regulator because the trustees are taking advice and they know that the offer on the table for an ailing corporate group is the best they're going to get. So they really want the transaction to go forward because they want the outcome, because they know that according to their advisor, they've tested it, is the best outcome. And they have the regulator dragging its heels about this, yes? And that's very frustrating for trustees. And none of this is going to help. When I say that, I mean that what you're going to end up doing with trustees is when you have a particular transaction and the employer group reaches out and says, or the proposed buyer and says, here's our valuation evidence, the trustees are going to have to get their own valuation evidence if they were going to sign up to it, because of course they can be liable themselves. Unlikely, but there you go. But all of this means that you've put extra layers on to deal with this. So what are my key little takeaways here before we open up for questions? First of all, as I've said, it's wider than the old section 38 material detriment. Valuation will be key. And one of the problems with valuation being key is that you can get 3 or 4 or 5 valuers in a room and they can all come up with a different valuation. And that's frustrating. And this is one of the reasons why we really have to try to work to get those regulations to be simple to use, so that it's not just the valuation, which there may be an argument about, but the way that you reach it could also be argumentative. And the more arguments and uncertainty you have, the more lawyers can go and have fun in court, which is what most of you don't want, but I like. So there we go. But this is why this is so important. Now, the new civil sanctions will create new risk and wider potential targets because there's no connected and associated. So this is where I think the real danger for professionals is. It's the civil sanctions. It's the same burden, balance of probabilities. The good news is it relates to the old tests. And I think unless you are involved in a very naughty case, and I use that word in a naive sense, but the guarantee stripping type thing, you're really looking at seeing whether you fall under material detriment. Was that too difficult for TPR? Their new tests are wider, but it's the material detriment that you need to focus on to see whether there's liability under the civil sanctions. So a provision which was not very much used, and I say that in the sense of not the subject of vast amounts of judicial interpretation, becomes really key on a test of civil sanctions. And that's what I find, if you're asking me what I think about this, really unsatisfactory. When you're bringing in new civil sanctions and criminal offences, I think the parties need to have some understanding of it. And what's been picked up is a provision under Section 38, which has not really been explored in law. And that's what makes it tough. The defence has never actually been the subject of any judicial consideration. That makes it really tough. And that's where, if I can put this as my frustration comes in, because I can advise as much as anyone else can advise, but I can't say to you, this is the case, look at these cases. Criminal offences, because of the higher standard of proof, I'm not sure that these will really be used. Again, I can't tell, but they are dangerous. They are there. Again, I think that the naughty cases might come in to prevent the recovery of, but again, it's really the material detriment area you're looking at. More information is going to be in the hands of the regulators, of the regulator. Will they act? I don't know. I think if anything, what is this doing? This is giving everyone an extra layer of paperwork, an extra layer of valuations, an extra layer of thinking what's going on here, yes? There are, though, a lot of transactional work which will still go through, and a lot of distressed corporate transactional work which will go through, simply because, as I like to say, nothing of nothing is nothing. If you've got an ailing corporate group and somebody's making an offer to buy it, I mean, the most that could ever be obtained is what's in the corporate group, unless you've got your little hidden guarantee. So on that basis, if you've got a distressed scenario, you may find that this doesn't really affect you as much. I don't know. It depends on what the deal is. Now, I was asked to have a quick look at restructuring plans, because this is, you know, you have no decent new legislation for years, and then 2 fun things come along at the same time. I know, humour me. So we have our Corporate Insolvency and Governance Act, and then we have the Pension Schemes Act. For me, who has, who does work in both these areas, you know, it's like Christmas come twice through. I've got 2 fun things to play with. Now, restructuring plans, they're the new, oh, let's go and do them. And the big question I keep hearing is, can you cram down the Section 75 debt in a restructuring plan? And here's my thoughts on it in a short time that we have, so we can have some questions if you've got any. I think the provisions would allow for the cram down, but it would probably be stopped by the judge, because I think the wording is wide enough to allow it, but I'm not sure whether a judge would actually sanction it. So that's my thought on it. Does that mean it can never happen? I don't know. Many years ago, for those of you who may remember, I dealt with a case of Capthing, Singer and Freelander, who you all know who they are. And I acted for the trustees in respect of an application we made to the court as to whether a Section 75 debt was assignable, because we'd got an offer to acquire the debt, which was of advantageous for the trustees because they could wind the scheme down. Instead, they were holding it open while the administrators kept making more recoveries. So they wanted to just bring this to an end, and we'd worked it all out. We went to court. And if you had asked me 10 years ago, did I think a Section 75 debt was assignable? I would have said, no, they're special. They're wonderful animals. No, they're not. Well, the court allowed us to assign it and said it was assignable. And so I just raised that when it comes to restructuring plans. I think you have to approach everything with an open mind to this. I argue that it was assignable, and I was even surprised in a way that it actually looked more and more assignable the more I was preparing for the hearing. But that's just because you start to believe in your case. But again, that's why I've fallen onto the side, also because I like to create havoc, that I think a restructuring plan is something that at some stage someone is going to have a go at. That's what people do. They have a go at it. It will go to court because that's what it does, and then we'll see where it goes. Now, will the TPR regard this as falling under a widened CN? Possibly. What about TPR considering the conduct of professional advisors? No, is the answer to that, I think. Simply because you have great protection in respect of it being sanctioned by the court. Would that be enough? I don't know. You know, these are all questions. I wouldn't get hung up on this last slide. I think we have so much more to deal with before we get to this, yes? But there is somebody who is going to try the restructuring plan with a Section 75 because that's what we're here for. We're here to always keep pushing. So it will happen. So my thoughts could be right, we just have to see. Thank you very much. Matthew, over to you for questions.
Well, thank you. Raquel, that was extremely interesting and wide-ranging, and I think it shows that our valuation teams may get reasonably busy with this type of work, as it seems to be central to many aspects of the new legislation. We have got some questions that have come through for you, and the first one is: do the new and wider TPR powers, combined with the criminal sanctions, simply represent a disproportionate response to the more extreme and isolated recent examples of employees and directors not taking their pension responsibility seriously? And I think the person asking the question is alluding to or talking about BHS and Carillion. For those employees that will continue to take their pension responsibility seriously in accordance with the existing anti-avoidance legislation and regulatory framework, should they be concerned by these new powers, provided they don't go as far as things that happened in the BHS and Carillion cases?
I mean, I think that sort of the extreme cases are always great fun to look at, you know. Carillion, their proceedings being considered, BHS, we all know about that. I think there is obviously criminal offences, criminal sanctions have always got a deterrent effect. Are they disproportionate? That depends upon whether their purpose is to stop the really naughty cases because they weren't stopping enough of them, or whether their purpose is to try to creep more into what I call the grey area. Put it in these terms: you have the very naughty cases and they deserve what they have coming to them. Is it disproportionate to make them criminal offences? For what it's worth, I think the civil sanctions would have been enough, but there you go, you know, that's my view, because they're quite draconian as well. What about all of those people in the middle area, the grey area? I think the difficulty for those of you in the grey area is the following. If you've always been taking your responsibilities seriously, engaging with the trustees, it's fine. But there may be an additional layer which is put in of paperwork that you need to be careful about, yes? Not on the day-to-day, but when it comes to what the company, the corporate group is doing, not how it's supporting the pension scheme. But if you go back to, for example, my little case study, you'll see there that what the directors of the company were proposing on the scheme was a really good deal for the shareholders. Are they going to be liable for the fact that under that particular scheme, the private equity was going to leverage by way of secured debt? And that's the real key. I think that everyone needs a bit of more alertness because of this new act. Will it change those on a day-to-day? No. The minute you start to get into transactions, yes. And that's where you start to have to really look and understand these new provisions. Is it disproportionate? You've got my view. I think civil would have been enough, you know, really. I think that would have been scary enough because you've taken off connected and associated. But I think it's the additional paper layering and record keeping which causes me some concern. Matthew.
Thank you. You may or may not know the answer to this, but do you know if the FRC has commented on the new TPR thinking and whether there's any joined up thinking between them?
Now, I don't know the answer to that. It may be out there, so I'm not going to say I don't think I've seen it at the moment. I mean, one of the problems is you can have digital overload where you keep checking what's coming out. So I don't know the answer to that one.
I thought that was a tricky one. There's another question which I know there's a number of quite a large number of professional advisors on the call. What are your top tips, if any, for professional advisor risk management in this new world when it starts to come to fruition?
I think my take on record keeping is quite important. Taking a step back. I mean, the problem is if you say to your risk people, I've been told to, you know, open a file and consider this, they'll say, don't do it, don't do it. I think that's too much. I think it's considering what's happening, taking a step back and starting to keep a record of it and testing it yourself. So I think as a professional, you need to have a look at that. You also need to respond to the consultations because the professionals, here's my take, professionals should not be liable. Those who help someone prevent the recovery of a pension debt, I have no sympathy with, you know, but those who are simply saying to the client, okay, this is how the deal can be structured, and I think this is fine. Yes, there's an argument that this might fall under here, but on my analysis, it doesn't. They may not want to do the work for the client because they might say, well, there's a risk there. So that's where you need to really think about it carefully. I don't think, for what it's worth, that those are the professional advisors that are looking to be caught. The ones who are the ones who are actively, this is my take, but it may not come out this way, actively assisting the dumping of pension liabilities, yes. But it's the grey area which is of concern. So those of you who are advising, I would say, you know, live in the real world, which I'm really pleased to say this because everybody tells me I don't live in the real world when it comes to record keeping. But check it carefully. Make sure that when you have, for professional advisors, and it goes into your risk team, you really, really, really need to have something in your risk team which understands what this is about. And I don't think there's enough, I'm sorry for those of you on risk teams on this call, I don't think there's not enough understanding of it, yes? And there is a difference between the ongoing and the insolvency cases. In the insolvency cases, it's a lot more urgent, you have to move fast, and you know, you've got a company which is probably devaluing. And that's where I think we're going to see quite a lot of movement when we come out of the furlough scheme and everything. How long the government is going to shore up companies, who knows? So I think your risk team, you need to keep records. You need to have a risk team that understand this area so they know what they're looking at.
I'm sure many of us will be making those briefings to our risk teams over the coming months. I think we've got time for one more. I don't know whether it's going to be quick or not, looking at the question, but do you expect the new regulations and act to impact flexible apportionment arrangements in any way?
I think it depends on how they're being used. RAAs are great because you get, when I say they're great, what I mean is that they require sanction of TPR, so they're easy to deal with. You know, you're not going to give sanction and then attack them because the whole idea is the TPR's assessed the CN or moral hazard and then says, yes, okay, we'll do this, yes. On the others, I think it depends. If they're part of a bigger transaction, they may be attacked. I think that they are very useful tools. And again, all I would say is you need to test them in line with what the new widened powers are here. Yep. And that's the way to look at them. Of themselves, they're very useful tools. They should continue to be.
Excellent. Well, thank you very much, Raquel. I mean, there's a couple more questions which we'll probably take offline and hopefully we can sort of feedback on those. But on behalf of Raquel and the BDO team, I'd like to thank everybody for joining and hope that everybody found that interesting and instructive. Thank you.